Please be seated. We had a little scheduling mix-up. We apologize for the delay. Good morning. We're here in the case of 1CICR 13-0629, State v. Portrell. Each side will have 20 minutes for argument, and appellant you may reserve a portion of the time for rebuttal, but you'll have to keep track of your time. And we are recording the argument both in audio and in video, and in a couple of days the case will the argument will show up on YouTube. So when you approach the podium, please identify yourself. We've conferenced the case, we've read the briefs, so we're familiar with the facts of the law, so just launch right into your argument. Counsel?
May it please the court, my name is Carrie McConaughey Nolan, here with my partner Todd Nolan from the Nolan Law Firm, and we are on behalf of Ms. Martina Bertrone, who is not present as she is in custody in the Arizona Department of Corrections. However, I would alert the court that numerous of her family and friends are here in her support today in the courtroom behind me. I think that there are numerous issues, Your Honors, and I would try to reserve 5 minutes or so for rebuttal if I can. There are numerous issues here that I think are excellent issues, but I would like to start with the one that I assume the court may be most interested in, and which I think is in most need of clarification and discussion, and that is the confrontation issue. So jumping right into that, I would immediately start with the opinion in Arizona versus Karp. And I would like to point out some of the distinguishing characteristics about Karp and about Joseph for this court, so that you're well aware of what it is that makes this case so much different from those cases, first and foremost. Here what we have is the criminalist Dawn Helm, who testified not just to her own opinion and to facts underlying that opinion that came from somebody else, but instead she testified to an opinion from somebody who was not present.
Well, counsel, perhaps you've read the record better than I have, but as I understand it, the criminalist who testified came to her own conclusions after reviewing the work of the non-testifying criminalist. It was her own opinion based on her own analysis, not the analysis of the other criminalist. If that's the case, then how is there a confrontation clause issue?
Here, Your Honor, what the testifying criminalist did was not only testify to her own opinion and her own conclusions, but she also testified to the opinions of whoever came before her, and who had to make conclusions.
And how did she do that? Did she say the other criminalist found such and such?
Yes, because what the other criminalist, assuming, again, it's a criminalist as well, which I will get more into as well, that has to do with Bullcoming and Melendez-Diaz and what they talk about. We are assuming this is even a criminalist here, because all we had were initials that they could not even identify as a criminalist, which first is one of the distinctions between this case and cases like Karp, where we had Valdez and, I apologize for not remembering her name at the moment, Kogler, who are both well-known criminalists who are at least named and can be determined to even be experts. Here, we don't even know for sure who it was who did the previous testing. All we have are initials.
Was there any objection to this at trial?
I'm sorry,
Was there any objection to the qualifications of the, I don't mean the the two opinions, but to the qualifications of the witnesses personally at trial?
There was not objection to the qualifications, Your Honor, but that goes into the entire argument regarding the objection or lack thereof, in that the defense attorney clearly and explicitly objected to the material coming in on foundation purposes, and by arguing that, look, I need to have somebody here who actually did this to testify to it, to the chain of custody, and
But
the
that's a
state
separate-
said, we'll tie it up later.
But that's a separate question. I mean, the defense counsel at trial never said, I don't even know if this person's a criminalist. The objection was, wait a second, we've got two opinions from two people, we ought to have two witnesses, right?
Right,
Okay.
right, and that was, and again, that came in with the state's representation that we're gonna bring other witnesses, was exactly what the prosecutor repeatedly stated when it was objected to, and then as it came to the close of the state's case, there were no other witnesses who fell into that, so then the objections came out again.
And the opinion that you're claiming violates the confrontation clause is that the known sample from the victim actually was consistent with the victim's DNA?
Because the known sample was what the opinion was of the person who was missing. Saying that that was in fact the victim's blood is what the other criminalist or whoever those other initials were came to the opinion of, and then that opinion is what the one who testified at trial then used as a basis for her opinion. So it's different from a situation where you have what, in fact, Judge Howe, you warned about in CARP, which was somebody acting as a mere conduit, in which Bull Cumming and Melendez-Diaz all talk about. This is that situation. She was a conduit for the opinion to start with that this was the victim's blood. And then she went on to use that opinion to make her opinion that it also matched the spatter in the bathroom on the wall. It wasn't just her making a decision or her own opinion based purely on facts, which was something similar in Joseph, where in Joseph you could say Dr. Keene's opinion was based on facts, data, which also was, I think, somewhat similar to what you were discussing in CARP as well.
Is there
Were
anything
facts.
problematic in the opinion of the... I know this isn't directly a confrontation clause question, but is there anything that you've identified that suggests that the analysis done by the non-testifying criminalist was subject to question?
Well, there isn't, but that's part of the problem here, Your Honor, because there's no ability to confront that or to question whether it was. And in fact, that is exactly the concern that the court had in Bull Cumming in that case, because they had a criminalist who did not testify who was on unpaid leave. And they said, look, if we had had this criminalist there, the defense could have cross-examined and confronted regarding, well, why were you on unpaid leave? What happened here? Maybe it was something like their testing procedures were off, or maybe they were lying about what happened in the process or in their conclusions. You can't confront them about that because you just don't know. And here, it's even less reliable or less valid in the sense that we don't even know if it was someone who could be called an expert criminalist, because all we have are the initials, and the one who did testify can't even say who those initials belong to.
Yeah, counsel, just so I'm clear about the parameters of your argument, if the record shows that, well, let's take this as a hypothetical. If the criminalist, well, if there was a technician or a criminalist who did the initial analysis, and a new criminalist comes along, reviews that analysis, uses his or her own expertise in determining that the sample matched, and then came to court and testified, do you agree there would be no confrontation clause violation because it's the testifying witness's opinion?
I would say that that is still suspect, given Bull Cumming and Melendez-Diaz, that is still somewhat questionable. But given the state of law in Arizona and the cases that have come out, that could be sustained. Here, that's not what happened, though.
So you're making a factual argument that there are actually two opinions and only one witness.
Oh, right. It's not.
And we can look at the record and figure that out then.
I believe so, yes. That, in fact, this isn't facts that are being relied on. Like, I mean, the scenario you're describing is more like Joseph, where Dr. Keene looked at what the other doctor did and then came to his own conclusions regarding what was logged in and such. But here, the criminalist who testified, Don Helm, never did any analysis of or even reviewed the initial conclusion that from this buccal swab that was taken, then it establishes it's the victim's blood. Therefore, then I compared it to this, and it was the victim's blood on the wall as well. There was no independent consideration of the underlying facts of that opinion. All that was used was the opinion itself, that it was that victim's blood. And she used that to base her opinion on it. So instead of making an opinion based on facts from somebody else who's not present, she made her own opinion based on an opinion of somebody else who wasn't present. And that is a violation of the Confrontation Clause. And again, that's what is very clearly warned about in Bull Cumming and in Melendez-Diaz, Your Honor. And again, I think that's what distinguishes it from the other cases that this court has seen and that the Arizona Supreme Court has dealt with as well. And also in that is that part of the analysis that we don't even know who it was. We don't even have an actual criminalist name or someone who can say, yes, this is a person who was working there. And I would also, Your Honors, distinguish what happened in the Williams case as well, because I know the state is relying on that quite a bit. That plurality opinion there, a big part of the analysis has to do with the fact that the DNA profile that they're looking at, while that may be similar to looking at a blood, profile or conclusions that this is a certain person's blood, the DNA profile there was conducted by an independent private lab for purposes that are unknown, that we don't know. Here, like they talk about in Bull Cumming and in Melendez-Diaz, we have a state lab who did this profiler, who did this determination of the blood and found that it was the victim's blood. So that is certainly for testimonial and court purposes. It wasn't prepared for any other reason, which is a big part of that analysis.
I know that
Williams.
DNA is it's very current to think that DNA is the Rosetta Stone of every case, but this is an identification of the defendant. This is identification of the victim. And so in looking at whether, let's assume there was an error, in looking at whether there was any prejudice sufficient to cause reversal, was there ever a theory that the victim wasn't even the victim? Was that advanced at trial?
Well, the problem with all of the testimony at trial, and the reason why it is prejudicial here, is because the victim's story was so inconsistent and so almost ridiculous compared to what the police witnessed, what he said on the night of the event, and then what he said in trial. It was just so, it was almost absurd, the inconsistencies with it. These weren't little inconsistencies.
There may have been problems with the victim's testimony on certain issues, but was there a theory of the defense advanced at trial that this victim was never even in the men's room, that he never was assaulted at all?
Well, during her testimony, Ms. Patron, when she testified at trial, specifically stated, obviously her first and foremost defense was that she was never in the bathroom and wasn't ever part of anything that happened.
The victim's DNA says nothing about whether your client was in the bathroom. That just says that he was in the bathroom.
Well, because the other part of it is whether or not he was even there under the circumstances he said he was. He stated at trial that he had been peppered sprayed. There was no evidence of that.
But that doesn't go to your Confrontation Clause issue. There may be tons of problems with the victim's credibility, but we're talking about prejudice from a Confrontation Clause violation. And as far as I can tell, the only thing that DNA would establish, if it were admissible, is that the victim was in the bathroom. And that doesn't seem to be the crux of the case.
But part of her defense, like I said, it may not have been the main part, but a part of her defense was that not only was she only in the bar and didn't see anything happening, but he was in the bar and then he was kicked out of the bar because he was there to buy drugs and such, and that he was kicked out of the bar for unruly behavior and such. So that was part of the defense in the sense that to the extent he was there at all, it was that potentially he was the disorderly elderly customer that she recalled having been thrown out of the bar. Not that he was ever in the bathroom.
Did your client ever deny or attempt to establish through cross-examination that the victim was never in the bathroom?
No, other than to say, other than to say that she did not ever see him in the bathroom, or that she did not, she only, to the extent she even remembered him at all, which I believe she didn't really remember him, but that she did remember someone had been in the bar and had been kicked out. So to that extent that he hadn't been in the bathroom.
Well, counsel, what was your client's defense? That whatever happened, she wasn't involved, or what the victim claimed happened didn't happen?
Both. She certainly was not involved, and that it simply could not have happened. That his testimony was so inconsistent and so ridiculous that it simply could not have happened. He was there at most. He was either outside or he came into the bar, but he was there to conduct a drug deal with Carlos Bally.
So the DNA evidence then is sole use was to impeach the victim?
No, it was actually used to establish that things did not happen. Not in the sense of impeaching him, but in the sense that there wasn't the crime that he was alleging occurred.
Well, but he said he said that a crime occurred. So if the DNA evidence.
Well, he also said to police on the night in question that things happened a completely different way and different crimes occurred than what he said at trial occurred. Okay. So the fact that he was then, whether he was really in the bathroom or not, gave him that confirmation and gave the jury that confirmation that what he had to say was really a viable fact, where otherwise it wasn't. So I think it absolutely is.
I think in fairness to your position, it's more than just the DNA evidence showing the victim was in the bathroom. The fact that there's blood in there is also circumstantial evidence there was a beating. Just people's blood just doesn't appear in a location unless there's some type of beating. So I think there's more to it than just that he was there.
Yes, and again, his entire testimony was suspect. So I mean, her ability to confront and cross-examine that in light of the fact that there's somebody coming in and saying, well, in fact, it was his blood that was in the bathroom, is limited. So and her ability to present her defense, any part of it.
Counsel, I guess my question to you is, the opinion here was that the blood found in the bathroom belonged to the victim. That was the opinion. This expert didn't come into court to say we took a buccal swab from the victim and we were able to prove that that buccal swab belonged to the victim. What facts can an expert rely on without having to have an expert or a witness come in and testify before they can get on the stand? I mean, isn't that the point of expert testimony? Rule 703 is that experts can rely on all sorts of information. They don't have to bring in a testifying witness to every single fact or piece of information upon which they render an opinion. It'd be impossible.
I agree, Your Honor, but here another important distinction that we haven't talked about yet, and I want to make sure the court is aware of, I cited to it in the brief, is the fact that aside from this is her opinion based on another opinion, is the problem that they specifically said at trial, she specifically said at trial, that they conduct, at the crime lab, they conduct these two analyses separately for purposes of making sure there's not any taint, for purposes of making sure that those two opinions are completely separate, and that then you say, yes, this matches this, and it leads to this conclusion. So she specifically testified that that opinion has to be separate from the other analyst's opinion as well, so that then they can come to the final opinion that, yes, this was the victim's blood.
They keep
Here,
it separate
you don't
in part,
have that.
though. They keep it separate in part, too, to avoid any issues of contamination and things like that, too.
Right. Right. So that's part of the other problem here, that having one person come in to testify to this other opinion doesn't keep them separate, and by her own testimony then causes a problem, because it's also violating that particular aspect of what the experts would normally rely on in that situation. I would like to throw out, I guess I'll reserve the rest for rebuttal, actually, since it's so short. Thank you, Your Honors.
Counsel.
Good morning, Your Honors. My name is Terry Christ, representing the state of Arizona, and may it please the court. As for this Confrontation Clause issue, we are under fundamental error review. There was one opinion, and there only needed to be one expert.
In Catholic, it seems like the initial argument is over whether there were one or two opinions. So can you discuss that and what the record shows?
The record shows that Dawn Helm testifies that she did the DNA profile on the blood on the bathroom wall. Someone else did the DNA profile for the buccal swab. She takes the two profiles, compares them, and finds a match. Generating a DNA profile is not an opinion or a conclusion or anything of that sort. It's simply interpreting the buccal swab into a DNA printout in order to determine whether or not there's a match. The non-testifying expert did not reach a conclusion that the buccal swab in fact belonged to the victim. The non-testifying expert would have no way of knowing that, in the same way that Dawn Helm, the testifying expert, had no first-hand knowledge that the blood on the bathroom wall in fact came from there for Exhibit 32, which was the one she did the DNA profile for.
Necessarily help you though that it's not an opinion. In a way, it's almost more difficult if it's not an opinion, right? This is one individual coming to a factual conclusion based upon the observations of the results of chemical tests, and you don't have that witness. So how does the fact that it's fact and not opinion make the case better for you?
In two regards, Your Honor. Firstly, the Confrontation Clause requires testimonial hearsay. So in order for there to be a violation, they have to show that the witness is testifying to testimonial hearsay from someone else. And if there is no such hearsay, then we don't have a Confrontation Clause violation. Here, nothing about what the non-testifying expert did is testimonial hearsay incorporated into the opinion of our expert.
Why not? I mean, it isn't what the non-testifying witness did critical to the establishment of a fact without which the testifying expert's opinion is useless?
Well, there's no statement. So
there's no statement, really?
It
seems to me that the statement is the results of analysis of this buccal swab shows this profile, this DNA profile, which you can rely on for later comparison.
Well, if you look at cases like the, in fact, there's a case I don't cite in the brief, but I was finding upon further consideration before argument called State versus Gomez at 226 Arizona 165, which talks a little bit about the DNA profiles. And admittedly, that's a pre-Bull coming case, but the conclusion of that decision was that there was no hearsay, or there was no Confrontation Clause violation in comparing the DNA profiles. But the other thing that I think it's important to keep in mind, and the reason why this isn't hearsay, is because we have the personal knowledge of this expert. So that our expert testifies that she reviewed the work of the non-testifying expert and then compared that to her own DNA profile. So we don't really have anything out of court here because we have personal knowledge. There's no hearsay that's being admitted.
But we don't know chain of custody. We don't know anything that went into that analysis of the buccal swab, right? We know what the result was, or what the result purports to be, but we have no idea how it actually got to that point. We don't know, for example, if instead of testing a buccal swab, the non-testifying witness happened to test the very blood sample that the testifying witness tested.
Well, if that were to happen, then I think our expert would have caught that in the review. Our expert was very clear on redirect examination that the work of the non-testifying expert was reviewed by two other people, but then she reviewed it too. So she personally is reviewing both the DNA profile and the buccal swab. And if for that review to be meaningful in any way, she would have caught an issue like that.
Tested the buccal swab?
She reviewed the work of the expert who did test the buccal swab.
And with the testimony about the chain of custody about the buccal swab?
The chain of custody for the buccal swab is this. So the...
No, but my first question is, was the testimony?
Oh, was there testimony?
Yes.
Yes, Your Honor, there was. There was chain of custody evidence in this case. And actually, there's a misconception in the record here that I think is important to point out. The defense makes a lot about the fact that there were initials, CEC, that my expert failed to identify. I can't find anything in the record to support that claim. The only person who says anything about there being another set of initials on this at all is the defense lawyer at the close of evidence. After all the evidence has been presented, he makes a motion to strike the testimony of Don Helm. And there he alleges that there was another set of initials. But I can't find any evidence or witness testimony or anything to substantiate that.
Did the court rule on that issue?
The court found at that point that the objection was untimely, because what originally had happened was there was an objection when another officer earlier in that morning of trial, Officer Ochoa, I believe, identifies the blood on the bathroom wall in that evidence bag and notes that there's another signature that he doesn't recognize. And at that point, the state offers this into evidence. There's an objection for lack of foundation, and the court conditionally admits it into evidence. Then later, Don Helm gets up, and the state lays all the foundation for that. This is her signature and the process by which she does her testing, and then offers into evidence again. At that point, there are no objections of any kind, and then the evidence is admitted unconditionally. It is our position that if the defense believed that there remained any lingering foundation issues or thought that there was a confrontation clause violation, that would have been the moment to make the objection, and then they didn't. So then when you have this motion to strike later after all the testimony has come in, no objections of foundation or hearsay or confrontation clause or anything like that have been made, the court says, well, now it's untimely, and then denies the objection.
Your friend argues that there are two opinions. That in the first opinion is from the non-testifying technician or criminalist or whatever qualifications that person had. Is that accurate?
No, our position is that there was one opinion in this case.
And what? Well, but you have to break that up into two parts, don't you? Because you've got to match the DNA that's in the bathroom with the victim.
Yes, Your Honor, you do. And so you need, the facts would be that we have one DNA profile, we have another DNA profile, and then the opinion is that they match.
What if the non-testifying witness had been the testifying witness and the testifying witness had been the non-testifying witness? Would that be okay?
No, that would not be okay.
Why is that? Go ahead.
Oh, it wouldn't be okay because the actual conclusion in this case, the opinion is that there's a match. So what you would have there is you would have someone who just said, I did a DNA profile for the buccal swab. That's all I did. And then you would have to have some kind of evidence about there being...
But then the non-testifying witness, who in this hypothetical is testifying, could say, yeah, I did the DNA analysis for the buccal swab, and then I reviewed the work of the person who did the DNA analysis on the blood, and they look the same to me.
If that were the case, if you just flipped which piece of evidence the expert had done the DNA profile on, and then the other profile was done by someone else, that would still be fine. It doesn't matter that it's the blood on the bathroom wall here as opposed to the buccal swab. What matters is that the witness who made the conclusion that there's a match is the person who testified.
So you're proposing a rule then that no matter how many experts actually perform scientific testing, Bookcoming only requires one expert in every case. As long as they review the other work, it's all fine. We can just produce one expert.
If there's only one opinion, then I think the holding in Williams and then in Karp would say that the things that expert relies upon, even if they would themselves would be hearsay, are not offered for the truth. And so as long as you had some independent chain of custody evidence to tie those things together like we do here, there wouldn't be a confrontation clause violation.
Well, of course it's being offered for the truth, though. I mean, Rule 703 allows experts to introduce the facts, observations, and opinions of others offered for their truth to support their opinions. I mean, there would be no reason to discuss it if it weren't offered for its truth.
Well, the conclusion is offered for its truth. And then you have to use chain of custody to establish that, in fact, the things that are being tested did come from wherever their respective sources were. And here we use the...
So, I'm sorry, is it your position then that the only opinion here is the comparison?
Correct.
And that everything leading up to the comparison is not a matter of opinion?
Correct.
And how do you draw that distinction scientifically? It seems to me that the analysis of the data coming out of the DNA testing is either... It's all pretty much the same. It's either fact or opinion And to say that findings A are the same as findings B is really the least opinion oriented of all of this testimony. The opinion is really that the material sampled accurately produced the results obtained.
I think that the DNA profile is simply raw data. It's just a translation of data extracted out of the buccal swab and the blood on the wall. And again, I think what's important to keep in mind here is that the testifying expert reviewed the work of the non-testifying expert and was able to say, based on my review, then we can compare these things together. So there's no hearsay being brought in from any out-of-court witness because the facts were actually known to this expert.
Counsel, I got two related questions. So the first expert did the DNA profile, and in the state's view, that is a fact upon which the testifying expert can rely on the 703 to come to her own opinion that the samples matched.
Yes, Your Honor, that is our position. If you look at Williams, for example, in Williams it was an outside lab who did it. There, the testifying expert had no personal knowledge of how the tests were done, what was involved, whether something was switched around in the process, chain of custody, any of that. All they know is that an outside lab sends them this DNA profile, and then they're able to compare it. And
in this case, was the testifying expert able to review what the non-testifying expert did and determine for herself whether it was validly performed or not?
The testimony at trial is that the non-testifying expert provided the profile and the swab to the testifying expert who reviewed them before making her comparison.
What does that mean to review them? I mean, doesn't she essentially have to take at face value whatever's submitted? Because she has no ability to check under the hood or determine what was actually done. So when we say review, I mean, how much stock should we put in that?
Well, firstly, I think if the review were to be meaningful, it would have to be more than that. There wouldn't be any sense in a review if all you could do is say, oh, well, those are the two things. It wouldn't really be a review at that point. You would just be looking at it.
And that's my question. Was there testimony to suggest that there was more than that?
There wasn't, but that's because there wasn't an objection to it. And also because we're on fundamental error review, we would presume that any silence in the record would support the conviction.
So the standard of review may save you, but assuming we were not on fundamental error review, would you agree then that the testimony was insufficient to establish that there was adequate review?
I think not. I think the fact that the expert says there's review would imply that the review would have to be meaningful. Certainly if they wanted to challenge that on cross-examination, the defense would be entitled to do so.
But it's the state's burden. I mean, shouldn't the state have the burden of establishing that there was meaningful review?
I think that'd be a question for the jury as to whether the review was sufficient or not. Of course, the jury has its own...
The jury needs evidence. The jury can't speculate. There was. It sounds like what you're saying is that there was really no evidence that the review was anything other than a cursory review that had no substance to it. It may have had substance, but there's no evidence that it did, right?
There's no evidence of exactly what the review would have entailed.
Well, but counsel, if there had been an objection, I take it there would have been testimony on that.
Correct. And that's why we have fundamental error review as a standard of review, because we don't want the defense to withhold objections and then to come back later and say, oh, well, you never developed the record on this or that. So I think it is important, maybe not critically important in the sense that we couldn't prevail on another standard, but I think it is telling why this is a fundamental error case in that there wasn't this opportunity to further develop what review meant in this case.
So your argument is the testifying expert simply relied on testing another expert and not the opinion of another expert.
Correct. The testifying expert relied on DNA profile generated by another expert. That DNA profile is simply raw data interpreted by the non-testifying expert. Our expert actually reviewed that data, and then did the comparison.
What was the interpretation done by the non-testifying expert? If it's raw data, it would seem that there's no interpretation involved.
Interpretation may not have been the best word. Translation, perhaps. Essentially, some way of extracting a profile out of the swab. I'm not really entirely sure how that process works, but again, a silent record here shows that the state didn't have the opportunity to develop it in the absence of an objection.
Well, what do you think the state could have said? I mean, if this is a practice that is well established, then surely there's a pattern of testimony that you would expect for giving meaning to the review that that the testifying expert conducted of the non-testifying expert's work. What sort of review would you hope for?
Essentially, some sort of review that would establish that, in fact, the swab here and the profile come from the same source.
And how could one conduct that review? Simply receiving a file that says, here are the results, here's the raw data from the examination of the buccal swab. What sort of review is the testifying expert to perform?
I would be hesitant to speculate, not having a background in DNA analysis, and I think the court should probably do the same.
Oh, I think the court is hesitant to speculate, which is why I'm concerned at the paucity of the record. It doesn't see, if we agree as a matter of principle that a cursory review or a mere acceptance of the work of another expert is problematic, then I'm wondering what else the law would require the state to show, or can the state simply show that we expected or accepted the work of a non-testifying expert and expect to have to back it up on cross-examination? Well,
I think that's the direction that cases like Williams and Karp and the rules of evidence go, which is to say, as long as you don't have testimonial hearsay being brought in, and it's not being brought in for the truth of the matter asserted, then it is the ordinary process of cross-examination that would test that reliability. Our rules of evidence still require the jury to determine reliability and the judge under maybe a 403 analysis, but here neither of those things occurred because, again, just no objection.
Well, what would happen then if the state just put an expert on the stand and said, in your opinion, is this blood the victim's? And the expert says yes. Thank you, no more questions. Would that be sufficient?
No, that would be subject to a lack of foundation objection. You would say objection, lack of foundation, how do you know that? Then you would have to say how you know those things. And then if one of the reasons why you knew that turned out to be testimonial hearsay offered for the truth, or you at least thought that, you'd make a confrontation clause objection. Part of the problem here is I think this is a chain of custody, lack of foundation issue on appeal wrapped in the clothing of confrontation clause. So it is not a confrontation clause violation if you don't call every witness in the chain of custody. And certainly you cannot characterize every issue of foundation as one of confrontation clause.
When the DNA result comes to the testifying witness, is it only the result they receive, or do they receive the paperwork that supports that? And does it show whether the non-testifying expert followed proper procedure?
I don't know if the record has an answer to that question. What I do know is that the testifying expert says that there's work done in the generation of the profile and that she reviews it. She's not entirely clear again on what that review would entail, but again I would fall back to the position that this is fundamental error.
Well,
so we just don't know.
It sounds like the rule you're proposing, though, leads to a potential for a complete end run around bulk going, because the state could simply identify one person to be the testifying expert in all cases. Then you've got a lot of criminalists doing a lot of actual work, but as long as this testifying expert receives their work, looks at it and says, in my opinion, this is good work, that would be sufficient. Is that your position?
No, it's not our position, because if you look at what happened in Karp, for example, where you had one person do the blood alcohol, if I remember that case correctly, but they didn't testify. Then you had someone else come in and just look over all the notes and say, in my independent opinion, his blood alcohol was thus. And this court upheld that. And that's consistent with the plurality reasoning in Williams. I think,
And is that what happened here?
I think that is what happened. Well, it's not exactly what happened here in that we're not reviewing the notes of another and forming an opinion. It's actually better here in that there is no opinion below. It's just a bunch of facts that our expert opines there's a match. I see that I'm out of time, so unless the court has any further questions, the state respectfully requests that this court affirms the convictions and sentences of the trial court. Thank you.
Thank you, counsel.
Your Honors, quickly, I would immediately point out that it's an incorrect representation of the record to assert that Don Helm did any analysis or review of the other criminalist's work. There was no indication in the record of that.
But, counsel, if the underlying fact of the DNA profile, if the DNA profile is a fact rather than an opinion, then your argument falls. Correct?
It would if it could be considered a fact, but this isn't a fact, Your Honor. This is an opinion. If we had a situation where this DNA profile and this DNA profile are out there floating and the person who testified at trial compared them up and somehow made the final conclusion, that's one thing. What we have is somebody who made a conclusion that this DNA profile, in fact, belongs to a certain person. That's the conclusion, that's the problem. That's the opinion. That's not a fact. That's actually someone taking that data and the facts and asserting the truth of them that they belong to this particular victim. And then the other analyst doing the same thing with what she reviewed. So the state's position that, well, if this one didn't testify, it would be a problem, but with this one not testifying, it isn't a problem. It's the exact same problem either way. If either one of them doesn't testify, they've both made their own opinions and they both have to be there, and it's a confrontation problem.
Is it your contention that the results of the raw results of DNA analysis is merely a fact, or that it's an opinion?
Raw results could be a fact, but here it's not a fact. It is the opinion that those raw results establish this particular person's DNA pattern. It's not just raw results. It is, in fact, that it is the victim, Mr. Cervantes' blood. That's the conclusion that we're talking about here. It's not facts. And it is what was warned about in CARP and in Bullcoming in particular, where we say this is testimonial in the sense that it is something that is being asserted for the truth, that in fact it belongs to that particular person. That's what the analysis part of it is in the opinion. And I would encourage you to look at, I apologize, Dawn Helm's testimony in its entirety, in particular at page 134, as we've cited, where she talks about the fact that she didn't do any review of that work. Anyway, and thank you, Your Honors, and sorry for going.
Thank you, counsel. Thank you for your argument. We'll take this matter under advisement and issue a decision in due course. We stand adjourned.